Alex here with a legal nuts and bolts video on chambers. What I mean by chambers is that little period of time when the judge goes, I'd like to speak to you both in chambers. And what they're doing is they're pointing at both the attorneys and basically pulling them back into their office so that they could talk about the case. I don't have a whole lot to say except that I don't like it. I, being a non-attorney, am very suspicious of the attorneys and of the judiciary. And so when they're back in a little back room, I worry what they're saying. I worry that they're going to argue the case in that little back room, that they're going to, reveal their personal biases, and that something could be said back there that should be on the record. And because I'm a person who has filed appeals before and won, I want things on the record as much as possible, because when you file an appeal at the Supreme Court, you can only cite things that are in the transcripts or, in the papers and pleadings. So anything that happens in the back room is a backroom dealing and is secret. And it's not just me. I've heard other people say the same thing. I've heard other people say, I don't like when my attorney goes back in chambers because I don't know what they're saying back there. I don't know if they're really fighting for me. I'm worried that they might say that I'm just an idiot and that the judge should just rule against me. These paranoias are very fair. It's fair to have these. These cases are so contentious. And the attorneys, I've done a couple of videos on attorney types already. Some attorneys aren't very scrupulous. Some attorneys just want to get rid of you. And I don't hold it above some attorneys to actually torpedo your own case for any of those various reasons that I mentioned. And the best place for them to do it is in that back room where nothing is being recorded. And it's just not good. There was actually an attorney in Reno, an attorney who said that he actually refused to go into chambers when a judge would ask him. And there was a particular judge who got livid. He took it as like an affront to his authority. He tried to explain to the judge that his clients don't like it. His clients become suspicious. They don't think it's fair, but this judge didn't care. In my opinion, this attorney is really a rare breed, one in a million probably. Because most attorneys like that little bit of privilege, that little bit of extra. Attorneys like that they can just approach the bench without even asking permission. A lot of them don't. Attorneys like that they have the power to go back in chambers and talk to the judge, just face to face and be candid and everything not be recorded. Whereas us, even when we're representing ourselves, we can't go back into chambers. I have never heard of a judge taking a self-represented party back into chambers. Never. If anyone has ever had the opportunity of doing that, please post it in the comments below. When I would represent myself, which was 95% of the time, the judge would never ask us to go in chambers, probably because I didn't have an attorney and he knew he couldn't do it. There was a few times, there were three times that I had an attorney in my child custody case, and let me think here. 2 times the attorneys went back in chambers. I feel like it was 2. When I do my series on the My Docket series, I'm going to go through each paper in the hearing one by one, and I'll be able to cover this more in detail there. But that's really all I can say. Is it illegal? Not that I know of, no. Should it be? I think it should. I really don't understand. I don't understand what the benefit would be. Anything that a judge needs to ask the attorneys in chambers, they could ask the attorneys in open court. The only purpose for doing it is to keep it off the record, and that just does not rub me the right way. Courtrooms are supposed to be open to the public. They're supposed to be transparent. The legislative arena is where the backroom deals happen, not the courtroom. I don't know what else to say about it. It's too bad that there aren't rules restricting it. I assume that the way that the law sees it is, since your attorney's going back there too, your attorney will have your best interest in heart. But like I mentioned earlier in this video, I highly doubt that's true all the time. And when it comes to child custody cases, I have more than just a slight suspicion that that's what happens back there. I believe that probably there's a lot of lawyers that are settlers, and if you want to know what I'm talking about, watch my video, Litigators versus Settlers. I think it's actually titled Settlers versus Litigators. I don't know. I have a feeling that there's settler lawyers back there who will probably just open up and say, my client's annoying. I want to get rid of him. I'm sick and tired of it. This is just me having seen that type of attorney before. When they are sick of you and want to get rid of you, they'll do whatever they can. And the fact that I just can't imagine wanting that type of attorney to go into chambers and say anything on my behalf, because that's the last thing that they're going to do. They're going to say things on their own behalf, in their own best interest, not on their client's best interest. So I think with that, I'm going to go ahead and end this video. I'm not sure if I mentioned this, but if anyone here has dealt with their attorneys going back in chambers and it rubbed them the wrong way, post it in the comments below, because people need to see this happens. And if anything, it's just yet another reason to represent yourself, just so that you can know that attorneys can't go back in chambers. And if an attorney was going to go back in chambers when you're a self-represented party, you would have to be allowed back there too. Otherwise, it would be considered an ex parte communication. Before I end this video, I do want to mention that there is one oddball situation when chambers is appropriate. I talked about it in my video, Children Testifying. There's this, I think there's this, I'm pretty sure there's something that came from the federal system that all 50 states had to adopt, but I'm not entirely sure. It had to do with how children were to testify. It may just be Nevada that did this, but there was a bunch of rules added to our rules of civil procedure that talked about how judges were supposed to go about having children testify, and one of the options was in chambers. That actually makes sense to me. Children shouldn't be in the courtroom testifying in front of both their parents. So there is one little exception there. But anyway, with that, and hold on a second. With that exception, there are stipulations in the court rules. If you watch that video, I think I talk about it. The discussion between the child and the judge has to be recorded. Or if it's not recorded, the attorneys have to have access through like a video feed or something. Anyway, with that, I'm going to go ahead and end this video, and I will see you guys next time.